Hi, I'm Sam, an associate at Wendy Hopkins Family Law Practice. With the summer holidays almost here, many separated parents may be questioning whether they need permission from the other parent to take their child on holiday. Many parents may be unaware that it is a criminal offence for a person to take or send a child out of the UK without the consent of those who hold parental responsibility or without permission from the court. This offence is classed as a child abduction, and if found guilty, it is possible that the perpetrator can be sent to prison, fined, or both. Whether permission is needed and who needs to provide it therefore depends on whether parental responsibility is held. A mother has parental responsibility automatically, but a father automatically has parental responsibility if he is married to the child's mother when the child is born or conceived, or if he later marries the child's mother. Since 1st December 2003, unmarried fathers who are named on the birth certificate also automatically have parental responsibility. Where an unmarried father is not named on the child's birth certificate, then there are options available that he can pursue in order to acquire parental responsibility. Providing there is no court order in place prohibiting this, then it is possible to take your child or children anywhere in England and Wales without permission of the other person who holds parental responsibility. This is not, however, always the case if there is a child arrangements order in place. If a child arrangements order is in place, outlining when and how contact is to take place, all parties must comply with the order. This means that you can only take your child or children on holiday in England and Wales during your court-ordered contact unless you have the consent of the other person who holds parental responsibility. If you do not have consent, then you need to obtain this. This could be potentially obtained through solicitor's correspondence or through mediation. Failing this, an application to the court will be required. If the parent takes the child or children on holiday regardless, then an order will have been breached. Permission is needed from all those with parental responsibility or the court before you can take a child under the age of 16 out of England and Wales. The situation is different if you were named as the person that the child or children lives with under a child arrangements order. In these circumstances, you may take your child or children out of England and Wales for up to 28 days without consent from the other person that holds parental responsibility. However, you can only take your child or children outside of England and Wales during your court-ordered contact unless you have the consent of the other parent. If you do not, then as I have previously mentioned, steps will need to be taken to obtain this. This could be through solicitor's correspondence, mediation, or by filing an application at court. In almost all cases, communication is key. It is advisable to provide details of your proposed holiday to the other parent, to include flight details, accommodation information, and contact numbers. You should do this as far in advance as possible so that you have plenty of time to try and agree the arrangements and to try and avoid any last-minute court applications. Should you require any further information or have any queries in relation to your summer holiday plans, please do not hesitate to contact us.